This Honorable Court of Appeals of Tennessee is now in session.
Good afternoon to the attorneys. We will proceed in this case as if you were in court, except you will not have to stand when you make your presentation. If there's any technical difficulties that develop, please let us know immediately so we can address those. Otherwise, I think that's all we need to consider at this point. Mr. Clerk, are there any preliminary matters?
No, Your Honor.
And will you call the case, please?
Savannah Leigh Jackson et al. Versus the State of Tennessee et al.
For the appellant, you may
Josh, I'm sorry.
You may proceed.
Thank you, Your Honor. Members of the court, I'm Josh Walker of the Knoxville Bar, here for the State of Tennessee / University of Tennessee today to present their argument. This case is about the lack of substantial compliance with Code Section 29-26-121A2E, the requirement that a HIPAA-compliant medical authorization be provided with a pre-suit notice in a healthcare liability action or before one is filed. In this case, very tragically, Branson Jackson was stillborn in December of 2018. Pre-suit notice was mailed in November of 2018. I have my dates wrong, but there are no timing issues there. That pre-suit notice is in our appendix at pages 34 through 36. And in there, it's shown that along with the College of Medicine Chattanooga and the State of Tennessee, a pre-suit notice was received by Erlanger Hospital in Chattanooga and Regional Obstetrical Consultants in Chattanooga. Upon receipt of those materials, the university sent records requests to Erlanger and Regional Obstetrical and received responses from both of those places saying that they had no medical records in the name of Branson Vance Jackson, and that is the name of the patient identified in the release sent with the pre-suit notice. And all of that information, the release itself, and the two requests and the responses are also included in the state's appendix to its brief. Based upon the response from these providers that there were no records available and the state's inability to get records, we filed a motion for summary judgment that the commission denied. And in its order, I think one important thing that the commission said was there's no indication that any search was undertaken or conducted using other information clearly contained within the authorization regarding Savannah Leigh Jackson, who is the child's mother, and that the fact that the records custodian did not turn up records showing Branson Jackson does not necessarily conclude that the release was substantially defective. And as I said, the motion was denied. Now, the first thing I'd like to address is that language. The suggestion by the commission that with this particular release, either of these providers could have searched for records for Savannah Jackson, the child's mother. It has to be a HIPAA compliant release, and HIPAA sets forth, as the court is well aware, certain core elements that have to be part of a valid release. Now, there is nothing missing from any of the core elements in this particular release, but the problem here is the release is for a person for which there were no records. And the two parts of these core elements that I think demonstrate the error of those statements from the commission is the first core element. You have to have a description of the information to be used or disclosed that identifies the information in a specific and meaningful fashion. This information was for the child, Branson Jackson, and no other patient. That's the only records that could be released via this authorization that the state received. And then the sixth core element is the signature of the individual. And if it's by a representative, the representative capacity has to be provided. And this release was signed by Savannah Jackson, clearly in the capacity as Branson's mother. So contrary to what the commission held under federal law, this is the only records that could be released were the child's, and neither of these providers had any records. And
who is the actual claimant or complainant in this case?
The claimants are both of the child's parents. It's Savannah Jackson, and the father's name is Mark Jackson.
Is on behalf of the child or what?
No, it is a death claim. So they would be the proper plaintiffs as opposed to the child being named. But it's
now, a assuming all went well, and this case went to trial, judgment was rendered. Okay, how would that judgment look?
Well, in a wrongful death claim, you only have the one plaintiff it's the deceased cause of action. It may be brought by one or more representatives, but there is only the one cause of action, and that is the cause of action that belonged to the deceased.
And the deceased is the child?
The deceased is the child, yes.
Okay. So what's wrong with the authorization at this point then?
Because the state could acquire no records at all. And that goes kind of into my next point, is if you look at the complaint, although the deceased may be the child and it may be the child's cause of action, if I can find this here, there are several allegations in the complaint, and those are set forth on pages 16 and 17 of the state's opening brief. And all of these allegations are about care provided to the mother, Savannah Jackson. It talks about that she's the one who presented at 29 weeks to Erlanger. She had a known history of diabetes and prior hospitalization for diabetic ketoacidosis. It talks about how the plaintiff, Miss Jackson, the mother, had been seen by resident physicians. The plaintiff, Miss Jackson, had an elevated heart rate, elevated respiration, elevated glucose, found to be distressed. The decision was made to admit her to the intensive care unit rather than labor and delivery. And in the intensive care unit, Miss Jackson was seen by more physicians. And then in paragraph 16 of the complaint, it talks about due to the condition of the plaintiff, the mother's diabetic ketoacidosis, as well as the lack of proper intervention, the decedent died and was delivered stillborn. So there's a direct allegation that it was the care or lack of care of the mother that led to the child's deaths. So therefore, the records pertaining to all these allegations about care either provided or not provided to the mother are...
Mr. Walker, let me interrupt you. My concern is, yes, they do allege these factual things that happened to the mother that led up to the baby being stillborn. But as I understand Mr. Hammontree's argument, he's saying we have made no claim for any injury on behalf of the mother. So that being the case, if the notices have been filled out with the mother as the claimant, then wouldn't you guys be making an argument that why are they getting medical records for someone who doesn't have an injury claim?
No, Your Honor. And I think that raises an important point that I need to address about the plaintiff's argument. The association with the patient and the claimant is set forth in 121A2, A and B. And those are for identification purposes. You have to provide the full name and birth of the patient whose treatment is at issue. B says you have to provide the name and address of the claimant authorizing the notice and the relationship to the patient if it's not the patient. C is a requirement for the name and address of the attorney sending the notice. D is the list of the name and address of all providers being sent a notice. And then the one that we're talking about, subsection E, you have to have a HIPAA compliant medical authorization permitting the provider receiving the notice to obtain complete medical records from each other provider being sent a notice. So with that requirement, you have to be able to get complete records. And the Supreme Court in both Stevens and Martin, I believe, has described that as complete and relevant medical records. And so whatever release it takes, and I would submit that in a birth injury case, it's probably necessary to have releases for both the mother and the child. But in this case, I mean, the statute requires that we're supposed to be able to get records from every other provider that got a notice. And we could not get any records from Regional Obstetrical or Erlanger. And Erlanger is where all of this evidently occurred. So the state has no ability to investigate or look into this claim pre-suit. And that is the main purpose of this part of the statute. I mean, I'm not trying to be flippant when I say this, but I think if the commission's order were to hold, then that would be, in essence, saying that we can try this case with no medical records because the state has to be able to get relevant medical records. It couldn't get any. So therefore, there are no relevant medical records. And I think it's I realize the silliness of what I just said, but I think that's kind of where this leads if it's followed to its logical conclusion.
That's not silliness. This is a unique point of law here regarding to this particular situation. That's not silliness. That's something we have not faced in the state before. So our question is whether or not those records of the child alone was going to be sufficient. And that's something we have to make a decision on. So it's not silliness. Right.
Well, and Your Honor, I'm getting down close to the end of my time here for the opening, so I guess I would like to just address the Gray and Dial Court of Appeals opinions. I can tell you that since the last brief was filed, the Supreme Court did deny the application for permission to appeal in Dial. That was still an open question when my reply brief was filed. But those are the closest cases that I can find to the case that we have here. And in each of those cases, it was almost identical facts. You had a group of medical providers at one facility and a group of providers at another facility. And when the plaintiffs sent pre-suit notice, they sent notice that allowed all the providers in one facility to only get records from that group of providers. And then the notice to the other group allowed those providers to only get medical records from that group of providers at that other facility. Neither group could get records from the other group of providers. And in both those cases, there was no problem with the release itself. It was fully compliant with HIPAA. They could get records from the limited number of people that their release applied to. It was a valid HIPAA compliant release. But because they could not get records from every provider that received a pre-suit notice, in each case, the providers at the other facility, both those cases ended up being dismissed. The first case came up on an interlocutory appeal, and then the second case came up on a Rule 3 appeal. And in both those, they found that it was the defendant's inability to get all the complete relevant medical records from all of the providers who had received a pre-suit notice. Even though the pre-suit notices were fine as far as HIPAA was concerned, they just didn't provide enough information. Both of those cases ended up, they reversed in the first case where the trial court had denied the motion to dismiss, and they affirmed the dismissal in the later case where the trial court had dismissed. But that's the...
Excuse me for interrupting. How do the medical providers determine the manner in which the records are maintained and whose name the records are placed for their purposes? Are there regulations, requirements that are standard and uniform? How is that determination made?
Your Honor, I don't know the specific determination. All I can tell you in all the birth injury cases that I have dealt with, the records have always, at least for the labor and delivery, which is what we're talking about here, those records that I have seen have always been held in the mother's name. And I've never seen records for a child until the birth or later. And I don't know in this case, I don't know because I've never seen the records.
Okay. Thank you, sir.
Thank you.
Thank you.
We'll hear appellee at this point.
Thank you, Your Honors, and it is an honor to appear before you today. And I agree with you, Judge, that I do believe this is a unique question under Tennessee law, at least so far as I have been able to determine. The cases that have been reported to date that I've seen and that Mr. Walker has cited several of typically deal with an issue with the provision or the sufficiency of an authorization. That is, either not all providers are included, which are required to be included, or there's not permission to release records to the proper entity or entities, or there's something wrong in the execution of the authorization itself. And I believe we have today before you undisputed, as far as I can tell, that there are no errors in the authorizations that we provided. They were executed with a proper signature. The names were spelled correctly. All providers who were given notice were also included to both to have the opportunity to receive records. So what this appears to come down to is when the statute says notice to be in the name of the patient, then an identity of the claimant, and then an authorization, whose names go where along those different options. And certainly under Tennessee law, a fetus can be determined to be a person for the wrongful death statutes. And our contention is, just like I think Judge Davis, you pointed out, had we sent a notice and had we sent authorizations only in the name of the mother, I could see us being here on the other side of this argument saying, well, yes, you got records, but we didn't include the name of the child, and that's the person who's passed away and the patient for the purposes of the notices. So I could see us being on the opposite side of this at that point. So there was a determination to be made. Our view was, and still is, the only claim we are making is for the wrongful death of the child. We are not arguing any injury to or seeking any damages on behalf of the mother for any personal injury to her or for any healthcare liability in the treatment to her body. This is only for the wrongful death of the child whose name was.
The wrongful death of the child in this particular case as a fetus will have to be based upon any treatment that the mother received or didn't receive, would it not?
Well, obviously, in retrospect, with how the records are documented, yes, sir. We would contend that treatment is to the child through the mother, that they are in sort of a symbiotic, certainly the most symbiotic relationship that exists for that moment prior to birth. You are correct in that, yes, sir. But in determining, what our concern has been is the burden this might place upon plaintiffs to determine how indexing or archiving of medical records are done. Does a particular hospital use the mother's name or the child's name, or sometimes the mother's name, sometimes the child's name? And what is the requirement for us to go towards to make sure we cover all possible archiving? And our contention, my contention is that there's no question we named who we consider to be the person harmed, the child, that these were compliant in all other aspects, and that, yes, it did not result in records being provided to the state because of how Erlanger or some of the other providers may have archived or indexed them. However, the statute, 2926-121 A2E states that it should be a HIPAA-compliant medical authorization permitting the provider to obtain complete medical records. And our contention is there's a difference in permitting and resulting in. We contend our authorizations permitted the release of any and all medical records that relative to the patient in this case, which we contend is the child, and that there was a valid permission under HIPAA to release those records. The fact that it did not ultimately result in the release of the records, we contend, is out of our hands. Once we give the permission, what the providers do or how the providers view that, as long as we've met the HIPAA requirements of a valid authorization, I don't know how much further we can go. And that's my concern. And that's our argument, is that we weren't trying to hide the ball here. We're not trying to play games. We're trying to meet the technical requirements and the letter of this statute, which I know has seen its way before you in many, many times and many variations, and is to try to do our very best to meet the very letter of that statute. And we believe that while this did not result in the provision of records, it meets the requirements of the statute in that it permitted the release of those. it was in the name of the only individual for whom we are seeking damages, and the only individual that we contend suffered an injury for which we're receiving damages. And there's no question about the validity of the actual notices or authorizations themselves, outside of just how providers may have archived or indexed their records. And that's really our argument.
Well, how much control do you have as far as how a hospital or a medical provider control or even compile records as far as a patient concerned, specifically a patient who's born stillbirth?
Your Honor, we have no control. And I'm not aware of any regulation, just like as Mr. Walker was, that would prescribe a particular way to do that. And I was certainly as surprised as probably Mr. Walker was when we were told that no records were produced. But we have no control over how this occurs at the various providers.
Is it not conceivable that a provider will have records on a stillbirth child?
Your Honor, yes, sir. And in fact, again, I'm not giving evidence, but I've had cases where there have been, for example, autopsies that are in the name of the child. So there are situations that I have anecdotally seen where there are records in a child's name as well.
Okay, thank you very much.
Thank you.
Do you have anything further? You have plenty of time to go.
No, I'm good. Thank you, sir.
Okay, thank you, sir. Okay, we'll hear your rebuttal.
Thank you, Your Honor. I'll try to be very brief. I would just go back to the Stevens case. Our Supreme Court has held that this requirement of providing the relief serves an investigatory function, equipping defendants with the actual means to evaluate the substantive merits of a plaintiff's claim by enabling early discovery of potential co-defendants and early access to a plaintiff's medical records. And while it may be harsh, our Supreme Court has said quite directly in Stevens that it is the plaintiff, not the defendants, that are responsible for complying with this requirement to equip defendants with the means to investigate before the suit is filed. And in this case,
I asked you the same question. How would they know whether or not the hospital or the medical provider has records on a stillborn child?
well, Your Honor, I've got two parts to answer that question. Number one, again, I refer back to the allegations that were the multiple allegations that are about the care provided to the mother, where she was admitted, her heart rate, her respiration, her glucose, what they did and didn't do with the mother during the labor and delivery and when she was in the intensive care unit. I mean, I think it's common sense that all those records that are related to complaints about care provided to the mother are going to be under the mother's names. And in this case, I guess there could be an autopsy. One did not turn up. The other way I would answer that question is, and again, I'm not trying to be flippant, but I think we've got to keep in mind there's a certificate of good faith requirement here that was met in this case. That means an expert looked at these records and said there's a basis for a cause of action in this case. Now, I've never seen the release that allowed that expert to review records and provide the basis for the certificate of good faith, but I'm imagining that release had to be in the name of the mother. And I think if the defendant ought to be able to get through the pre-suit notice release provision, the same information that the certificate of good faith is based on. Now, again, I don't know that, but that's what I think. And I think that's the best way I can answer that question. The last thing I would want to add is that in the Buckman, Lawson, and Hamilton, Abercrombie opinions, the court has held in all those that defendants are clearly prejudiced when unable, due to a foreign procedural error, to obtain medical records needed for their legal defense. And here we couldn't get any, and I think that's the definition of prejudice.
Thank you, sir.
Thank you.
Okay. Thanks to both of the attorneys for your presentation. Your case has now been submitted to this court. You will receive our opinion and ruling within a due course of time. Thank you again, and the attorneys may be excused.
Thank you,
This
Your
honorable
Honor.
court is now
Thank you,
adjourned.
Your Honors.
Mr. Clerk, will you adjourn clerk to tomorrow morning?
Yes, Your Honor. This honorable court is now adjourned till tomorrow morning.
Thank you very much.